Morning, are you Harold Middleton?
Yes.
All right, so this is People v. Harold Middleton, file 25-70550FH for arraignment. Counsel, you want to state your appearances, please?
Anthony Julie on behalf of the people.
No, not Governor, for Mr. Middleton, who appears remotely from the Chippewa County Jail.
Okay, have you had a chance to review the charging document with your client?
I have, Your Honor. He did not want to waive any sort of formalities or readings. At this time, he wants a formal.
This isn't just another routine court appearance. This is a case where the stakes escalate fast. A defendant facing multiple felony charges, a habitual offender notice that could turn years into a lifetime behind bars, and a courtroom where every word matters. But that's only the beginning. As we move deeper, we'll see another defendant fighting for leniency after a downward spiral involving substance abuse, threats, and missed second chances. And just when you think you've seen it all, a third case flips the tone completely, raising questions about
arraignment conducted.
No problem. All right, Mr. Middleton, are you Harold Stanley Middleton III?
Yes.
All right, Mr. Middleton, you are charged in a felony information with 3 counts as well as a habitual fourth notice. In count 1, breaking and entering a building with intent. It alleges that on or about May 6th, 2024, in the village of Wolverine, Sheboygan County, that you did break and enter a garage located at 5734 Cedar Street, Wolverine, Michigan, 49799, with the intent to commit the crime of larceny therein. That would be a felony punishable by a maximum of 10 years in prison. The prosecutor has filed a notice that you have been previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about April 19th, 2022, you were convicted of possession of methamphetamine in the 50th Circuit Court for Chippewa County, state of Michigan, and on or about April 19th, 2022, convicted of malicious destruction of fire or police property, again in Chippewa County, state of Michigan, and on or about April 23rd, 2024, you were convicted of maintaining a drug house in the 50th Circuit Court, again for Chippewa County, state of Michigan. With that habitual offender notice, that would increase, in the court's discretion, the maximum penalty for the B&E on count 1 from 10 years to a maximum of life in prison. Count 2, larceny, $1,000 or more, but less than $20,000, alleges that on or about the same date and location as in count 1, you did commit the offense of larceny by stealing a 2010 Ford F-150 that belonged to a Lance Michael Harmer. The value of the property stolen was $1,000 or less, $1,000 or more, but less than $20,000. That would be a felony punishable by a maximum of 5 years and or a $10,000 fine, or 3 times the value of the property stolen, whichever is greater. However, with the habitual fourth notice, that would again increase the maximum penalty in the court's discretion to life in prison. Count 3, motor vehicle unlawful driving away, alleges that on or about the same date and time as counts 1 and 2, and at the same location, you did willfully and without authority take possession of and drive or take away, or did assist in or was a party to such taking, possession, driving, or taking away of a motor vehicle, to wit, a 2010 Ford F-150 belonging to another, to wit, Lance Michael Harmer. That's a felony punishable by a maximum of 5 years in prison and a suspension of your driver's license by the Secretary of State. But again, with the habitual fourth notice, in the court's discretion, the maximum penalty could be increased to life in prison. Mr. Middleton, do you understand the maximum penalty of the charges against you, or do you have any questions for me or your lawyer about that?
No, I understand.
Okay, and Mr. Nightingale, how does Mr. Middleton wish to plead to those
Not guilty.
offenses? Okay, we'll enter a plea of not guilty, Mr. Middleton, as to all 3 counts, and Mr. Nightingale is a forensic center referral requested.
No, Your Honor.
What would be the estimated length of trial?
I would say 2 days.
Okay. And I did see there was a preliminary examination in this matter and a transcript prepared. Are you anticipating motion to quash?
I am, Your Honor. I will file it as soon as I can get it drafted.
Okay, we can set this then for a docket call, and you can notice up a motion to quash on September 30th at 10:30 a.m. And is Mr. Middleton expected to still be in the Chippewa County Jail at that time?
He will be in the jail still at that time, yes.
Okay, we'll have that be a Zoom appearance on his part. Anything further from the defense?
No, Your Honor, thank you.
Anything further from the people?
No, thank you.
Okay, Mr. Middleton, your lawyer's going to file a motion challenging at least one or more of the charges up here. And we're going to hear that motion and have you zoom in on September 30th at 10:30
Okay,
in the
but I
morning,
would,
all right?
I would like to be there. I could,
You'd like to be there in person?
yeah,
All right, well, I'll have you talk with Mr. Nightingale about that between now and then. I think it's not required that I would have you be in person for that since it's just some legal arguments. But if he wants to make that request, I'll discuss that with him and the prosecutor beforehand. All right, otherwise we'll
Right.
probably have you zoom in. I'll see you then, sir.
and I would like my discovery pack as also.
Okay, Mr. Nightingale, have you been provided with discovery? from-
Yes, Your Honor.
I would
Mr.
like
Middleton,
my
it should be on the way to you.
transcripts from my
I think it got
prelims,
mailed
too.
out late last week.
So, Mr. Middleton, when you're represented by an attorney, then the prosecutor doesn't present it to you directly. They give it to your lawyer. He's indicated he has it and he's getting a copy out to you. Anything else?
No, just waiting on my discovery pack that I've been waiting on for a while now.
Okay.
I mean, it is my
Well, you
right
should-
to have it, so,
Yep, and your lawyer's got it and he says that it's on its way to you.
okay. I would like
All
my
right,
other,
let's
my transcript for my preliminary exam too. I'd like all that too.
Okay. Well, again, that's stuff you'd request from your lawyer, not from me. He's got it
And
and
I've
he's
been
representing
requesting.
your interests. Okay. All right, you have a good day, sir.
Yep.
We've got sentencing and People v. Matthew Repenhagen. It's 3 file numbers, 24-6942 FH. Attempted witness intimidation, a 2-year high court misdemeanor. 0 to 9 guidelines, 24-6943 FH. Possession of buprenorphine, 4-year felony, 0-17 guidelines. And 24-6944 FH, witness intimidation, a 4-year felony, 0-17 guidelines. Counsel, please state your appearances.
Melissa Goodrich, one county prosecutor.
Kevin Pomeranke, MIDC, appointed counsel on behalf of defendant Matthew Repenhagen, who is seated to my right this morning.
Great, thank you. And Mr. Pomeranke, have you had a chance to review the pre-sentence report and recommendations with Mr. Repenhagen?
I have, Your Honor, and as far as factual things go, there are no additions or corrections.
Any scoring challenges?
There are no challenges to scoring, and we agree with the guideline ranges are.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, you're right.
Mr. Pomeranke, anything you want to say on behalf of your client?
Yes, just briefly, Your Honor. I've gotten to know Mr. Repenhagen throughout the past few months, Your Honor, working these 3 files. Every encounter that I've had with him has been pleasant. After reading through the material in the case, which was somewhat highlighted throughout the PSI, I understand that Mr. Repenhagen is probably in a much better place now psychologically than he was when these warrants were issued and when he was arrested. I think he's had a substantial time to think about his conduct and behavior and how he has managed or ill-managed some of the bigger things that led to his using again. My understanding, talking to Mr. Repenhagen and reading this material, that he was able in his life to put his substance abuse behind him for some time, and it crept back into his life, and it's had some pretty devastating consequences. It's also not enabled him to be able to deal with other consequences, perhaps out of his control or within his control in his life. And I think this, especially the last charge, is a culmination of everything sliding off the rails. And I think Mr. Repenhagen lashed out certainly inappropriately. However, I think he's a lot more grounded now. In talking with him, He has been in counsel with his clergy, who's been in to visit him on a pretty frequent basis throughout his stay so far. They're working on getting him potential employment lined up for when he is released in the future, as well as looking at developing other supports in the community for him, as he'll have to endure a new chapter of his life and pretty much start over. However, I believe he's ready or preparing for the ready to be able to do that. Your Honor, with that, I would say he is employable. He is amendable to everything that is being asked of him in the recommendations. And I believe this is an individual that has succeeded before in probation and could succeed again. I know the recommendation for the last file in this matter recommends a additional 9 months. We're asking that the court consider that part of that 9 months may be held in abeyance, so that Mr. Repenhagen can potentially taste some part-time work or seasonal work this summer. There are certainly probably more opportunities to make some money around here in the summer than there are in the winter. However, we respect the department's recommendation. We ask that the court consider all that. I know Mr. Repenhagen would like to address this court briefly.
Okay, thank you, Mr. Henrique. Mr. Repenhagen, is there anything you want to say, sir?
Yeah, you want to stand up?
Sure.
I just want to apologize to the victim here. I know we're not supposed to use his name, so I just wanted to take the time to apologize to him and his family for all this stuff. And like you thought, my friend was saying that I've been going to church in AA since I've been locked up, and working on the sober things sober as best I can. Like I said, I just asked the courts for an opportunity to prove that. So thank you.
All right, thank you, sir. Mr. Goodrich, any recommendations from the people?
Oh, yes, Your Honor, thank you. The defendant is 33 years old. He has 1 prior felony and 3 prior misdemeanors. He has a history of substance abuse, has already served 2 terms of probation, 2 jail sentences. In 2010, he served 3 months. In 2020, he served 6 months. For these 3 cases, he had sold his prescription to a confidential informant, then had threatened him thereafter. He was incarcerated but released to residential, had walked away after 9 days, and then did further threats to that CI, which brings us here today. He has been incarcerated for 272 days. I would ask the court to follow the recommendation in the PSI.
Thank you, Mr. Repenhagen. If you please stand for the court sentence. You know, Mr. Repenhagen, you're in your 30s now, and although you're certainly not unknown to the local criminal justice system and authorities. You made it to 30 without much of a felony record at all, and you had a couple controlled buys of prescription Suboxone. That's serious. It's felony. That's not the end of the world. And you took a bad situation and made it unnecessarily worse for yourself by kind of lashing out toward the CI that had arranged those purchases. It's not their fault, right? I mean, they arrange it, but nobody made you sell that. And my guess is, if you're being honest with yourself, it's not like those are the only 2 instances in the history of the universe of what was going on in your life where you did that. You know, that CI could call me all the day long and I wouldn't sell them drugs because I don't sell drugs. So, and if you want to move forward with recovery, resentments, whether they're real or imagined, are going to get in your way. So you ended up doing more jail time because of your threatening statements made to the CI. I mean, I'm sure you know that. I just want to make sure you appreciate that, and also that you were given an opportunity to go to residential treatment, then you walked off from that. So it's not like anybody in the system was trying to make life hard for you. You made life hard for you. So I hope that you've had some time to think about that, and are gonna think you're capable, obviously, of not getting into all sorts of felony trouble. Now, with the kind of record that you have from this case, if you were to get in felony trouble, the next time it's probably a prison sentence. And this situation could have been a close call for that. Didn't start that way, but it could have become. In any event, taking all these things into consideration, including all the information in the pre-sentence report, including the advisory guidelines, it's the sentence of the court in file 6942 that you be ordered to pay $68 in state cost, $130 in the crime victims assessment, $350 in court costs, and that you serve 272 days in the Sheboygan County Jail with credit for 272 days previously served. And that's a sentence within the advisory guidelines. The in file 6943 for the possession of buprenorphine, 0 to 17, I'll place you on probation as recommended for 18 months, subject to the terms and conditions listed on pages 3 and 4 in the pre-sentence report. They include treatment, they include a curfew, it includes no contact with the victim in the other cases. It includes full-time employment. I'm going to order you serve, or you pay $68 in state cost and $130 in the crime victims assessment. I'm not, Agent Martin, I'm not going to assess paragraph 21 of the court costs. I'm just going to assess it in the one file. So I'm not going to assess the court costs in 6943. I will, in that file, also order that you serve 272 days of jail, give you credit for 272 days previously served. And again, that's a sentence within the advisory guidelines. In file 6944, witness intimidation, there's $68 in state cost, $130 as a crime victims assessment. I am not going to order court costs in that file either. Now, that was committed while you were on escape status from having walked off on furlough. Under the statute, I believe that is mandatory consecutive sentencing. Even if it were not, I think it would warrant the application of discretionary consecutive sentencing because you were on bond and on a furlough for a similar threat against the same person. So for that, I'm going to follow the recommendation and order that you serve 9 months in the Sheboygan County Jail. You get no credit for any time previously served because this sentence will run consecutive to files 6942 and 6943. I will, however, indicate on the judgment of sentence that the court has no objection to you participating in the CBT program or trustee program of the jail if they determine you eligible for that. And that can take some time off your sentence as well. All right, so, within 24 hours of your release, you have to contact your supervising agent and Mr. Repenhagen in all 3 files. If you wish to appeal, you can file an application. If you wanted a lawyer, I'd give you one. If you asked within 6 months, so we're going to hand you some appeal paperwork. It's 2 copies in each of these 3 files. One of them we're going to ask you to initial so we have a record that we gave it to you, and the other one is for you to fill out if you want to take an appeal. Do you have any questions for me, sir?
No, sir.
Okay, good luck to you. Thank you, Mr. Pomeranke. Is that all you have this morning?
That's all I have. Thank you, Your Honor.
6874FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
Liz Elliott on behalf of Brianna Gaffne, who is to my right.
Good morning, and this appears that it was a successful delay period with a plea agreement for a reduction to the misdemeanor child abuse 4th degree. Have you had a chance to review that pre-sentence report with your client?
I have, Your Honor.
Do you have any additions or corrections?
I don't.
Anything you'd like to say on her behalf?
Yes, Your Honor, thank you. Your Honor, Brianna has proven herself by her performance while she's been on probation. She's complied with all of the terms. She works full-time. She takes care of her 2 young children. And we agree with the Department of Corrections here and are asking the court to follow the recommendations and deem the delay period successful and enter the misdemeanor charge that's set forth in the plea agreement. Brianna also wants to let the court know that the bench warrant in Kent County has been taken care of, and she is on a payment plan with that court. Thank you.
Okay, very good. Thank you. Ms. Gaffney, you don't have to tell me anything today, but it is allowed. Is there anything you want to say?
I definitely have learned the laws about this situation. It was a complete accident, and I do appreciate the court's opportunity for the delayed sentence.
Okay, thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, I also support the recommendations. My only concern was the bench warrant, and I appreciate that Ms. Gaffney took care of that.
Okay, Ms. Gaffney, it appears that you did well on the delay of sentence. I'm glad to see that. I'm glad to see you doing well. So I hope you continue on a healthy path for yourself and for your family. The court would find that the terms of the delay were successfully completed. So upon presentation of an amended charging document, which the prosecutor does have, you accept that, you consent to the filing of that, Ms. Elliott?
Yes, Your Honor, thank you.
All right, so we have the amended information with the misdemeanor charge. We're going to enter a judgment on that count pursuant to the plea agreement. I'm not going to impose any additional jail or probation at all, but because we are entering that judgment of conviction, you may file an appeal if you wish by filing an application. If you wanted a lawyer, I'd give you one, but you'd have to ask within 6 months. We're going to hand you a piece of paper about the appellate rights. Ask you to initial one copy for us so we have a record we gave it to you, and the other one is for you to fill out if you want to appeal. Do you have any questions for me, Ms. Gaffney?
No, I appreciate it.
Okay, good luck to you.
Thank you. Your Honor.
All right,
Thank you. Have a great day.
you too.
This courtroom session shows 3 very different paths through the justice system. One defendant faces potentially life-altering consequences due to prior convictions and serious felony charges. Another receives a structured but firm sentence after a pattern of poor decisions, with the judge making it clear that future mistakes could mean prison time. And finally, we see a rare moment of leniency, where compliance, responsibility, and follow-through lead to a reduced charge and no additional punishment. It's a powerful reminder that outcomes in court aren't just about the crime. They're about behavior before, during, and after. So what do you think? Did the court get it right in all 3 cases? Or should the outcomes have been different? If you found this breakdown insightful, make sure to hit that like button and share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.